Viewers, jail is a regulated space. Inmates are forbidden to communicate with the outside world. But this hasn't prevented Jail Chief Minister Arvind Kejriwal from issuing orders necessary to run the government, the Delhi government. How does one do this without recourse to a phone or face-to-face meetings? But the AAP has clearly found a way, and an order issued by Kejriwal has been read out in the public domain. It has come as no surprise then that the Bharatiya Janata Party has filed a complaint with Delhi Lieutenant Governor V.K. Saxena in the Enforcement Directorate, rather the Election Commission, against Delhi Chief Minister Arvind Kejriwal. The BJP has demanded an inquiry into the alleged typed order issued in the Chief Minister's name on his official letterhead. The BJP says that this undated order is, quote, fabricated, unquote, by someone who is illegally using the Chief Minister's office. Since Chief Minister Kejriwal is in ED's remand and cannot issue orders without the court's permission, he has committed a legal infraction. This is what the BJP is saying. The AAP has, of course, rubbished the accusation. Listen in, viewers.
मैं अरविंद केजरीवाल जी की तरफ से सभी दिल्ली के लोगों को ये आश्वस्त करना चाहता हूं कि आपका मुख्यमंत्री चाहे जेल में है, मगर सोच वो सिर्फ आपके लिए रहा है, सिर्फ और सिर्फ जनता के लिए मुख्यमंत्री सोच रहे हैं। और उनकी चिंता यही है कि उनके जाने के बाद पीछे कोई व्यवस्था खराब ना हो। और हम सब लोग जो उनके सिपाही हैं, हम सब लोग 24 घंटे काम करेंगे, मगर कोई दिक्कत जो है दिल्ली वालों को नहीं होने देंगे। ऐसी मुख्यमंत्री जी की इच्छा है।
आज मैंने दिल्ली के उपराज्यपाल और इन्फोर्समेंट डायरेक्टरेट को आतिशी जी और उनके साथियों के खिलाफ कंप्लेंट की है, जिन्होंने मुख्यमंत्री जी के नाम से एक इलीगल ऑर्डर दिखाया और यह कहा कि दिल्ली के मुख्यमंत्री का ऑर्डर है और मुख्यमंत्री जी ने ईडी कस्टडी में जेल में रहते हुए ही ऑर्डर पास किया है। ये टोटल इलीगल था, अनकॉन्स्टिट्यूशनल था और ये मुख्यमंत्री के ऑफिस का मिसयूज है। ये क्रिमिनल कॉन्स्पिरेसी है दिल्ली के लोगों के साथ, दिल्ली के मुख्यमंत्री के दफ्तर के साथ और दिल्ली की चुनी हुई सरकार द्वारा अपने मुख्यमंत्री के पद का दुरुपयोग किया जा रहा है।
Well, even as the BJP escalates the matter, and the AAP has cited the fact that there is no express legal bar on Kejriwal continuing as Chief Minister and continuing to run the government, here are some hard facts that bring clarity on this issue. The hard facts, viewers, always on this show to bring you closer to the nub of the issue so that you can understand its contours. The question we are asking, can Kejriwal rule from jail? Now, what does the law say? Under Article 361 of Constitution, only President and Governors enjoy immunity from law till their term expires. A Prime Minister or Chief Ministers are subject to equality before the law and don't enjoy the cover of Article 361. But arrest of the Prime Minister or even the Chief Minister doesn't automatically warrant disqualification from their post, viewers. No explicit prohibition under law against the Prime Minister and Chief Ministers from conducting official responsibilities while under arrest. In fact, the RPA, the representative of People's Act, says, 1951 says, disqualification provisions for specific offences necessitating a conviction. So only if you are convicted do you become eligible to hold office. But there are practical hurdles, viewers, and I want you to look at these. Delhi is a union territory and Lieutenant Governor is deemed an equal stakeholder in governance. Files that need to be presented to LG, usually in Delhi, go through Mr. Kejriwal. Now, Mr. Kejriwal is in jail. How is he going to get those files? Kejriwal presides over cabinet meetings. He now must delegate this task because he's in jail, viewers. He can't preside over meetings. He can't even do Zoom calls. He doesn't even have a phone. Therefore, it becomes impossible for the Chief Minister to hold these cabinet meetings or sign off on files which the LG has to, of course, look at. So there's this impracticality. It's impossible for the Chief Minister to conduct mandated, now these are mandated by law, in-person meetings to decide on transfer and postings. You can't do it sitting in some other part of the world, viewers. You have to do these in person. It's mandated by the rules. So he'll have to delegate, viewers, to somebody else to do this, and that person must have the equal authority. Must be, in other words, a chief minister. Then there's a jail manual rule 1349, which forbids inmates from attending meetings, making phone calls or signing documents, as I've just told you, viewers. The known unknown, of course, and that's another aspect that we need to focus on. The LG could cite all these impracticalities and build a case to allege failure of constitutional machinery and then impose President's rule till the term of the Assembly ends in February 2025. This is within his power. There is also, of course, moral precedents. Past chief ministers, when they've been arrested, Lalu Yadav, J. Jayalalitha and Soren handed over their chief ministerial responsibilities to others when they were jailed. But they were also convicted, viewers. They were convicted. In some cases they weren't. But they did hand over responsibilities to proxies. Denied bail repeatedly. AAP ministers Jain, Satyendra Jain and Manish Sisodia had to quit their posts. In fact, this was something that even Kejriwal sort of affected. Will he apply the same yardstick to himself? Again, I'm bringing in the moral precedents, views. Madras High Court questioned how DMK Minister Senthil Balaji could continue to be a minister after he was arrested, though not convicted, viewers. So precedent exists in law. And viewers, then there is also another law which I want to talk about. It doesn't apply to Mr. Kejriwal as things stand, because he holds a constitutional post and is elected to office. It's called the All India Services Discipline and Appeal Rule 1969. Now what does it say? It says a member of the services, which is the IAS, IPS or IFOS, who is detained in official custody whether on criminal charges or otherwise for a period longer than 48 hours shall be deemed to have been suspended by government concerned under his rule. Now, if this rule, viewers, can apply to civil servants, can it be used? I'm only asking this question. Can it be used to build a case, to bring equity under the law against Mr. Kejriwal? There are many, as I said, viewers, factors that come into play. The moral factor being, of course, the strongest. Yes, you might be allowed by law, but what about morality? What about the spirit? What about upholding the spirit of the law? Sanjay Hegde, a senior lawyer, is with us. He, of course, appears in the Supreme Court. Ujjwal Nikam, senior lawyer, needs no introduction. He also appears in the Supreme Court, is with us. So I want to first ask Sanjay Hegde. Sanjay Hegde, yes, fine, at this moment the law doesn't really go against Mr. Kejriwal, but what about the spirit of things? I mean, you have seen, I've introduced the viewers to the impracticalities of it all. And there is, of course, some mandated requirements also of the Chief Minister being there in person to oversee certain tasks. Now, doesn't that sort of apply to Mr. Kejriwal?
Well, as far as the practicality is concerned, it's always open to the court to find a way out. And courts have at times found a way out. I remember long ago that during the Nehru era, when Balraj Sahni, the actor, was put in preventive detention, he was let out every day to complete a film. You also have had the Sahara Shri, who was detained by orders of the Supreme Court, allowed to transact business because his business had to be liquidated. So it is not as if the situation renders authorities powerless. The question is whether there is in law under the Constitution a disqualification. And as long as somebody is not convicted, there is no disqualification. Because if you were to take the other way around, that the moment somebody makes an accusation and you are taken into custody, that's it. You have to step off. If that were to be the case, then any investigating agency could unseat any sitting chief minister or possibly even the prime minister. No parliament, no legislature has yet taken that call. See, ultimately, who decides disqualifications? Or in what situations should people be disqualified? Parliament itself has the power. Parliament has not yet exercised it. Now, you may think...
Can I ask a rebuttal question to you?
Yeah, please go ahead.
Mr. Hegde, look, this is a slightly unusual circumstance, and therefore I'm focusing a little bit more on upholding the spirit of the law. Legality, you might be on strong ground, maybe Mr. Kejriwal is on strong ground. But I don't remember a time when a chief minister and two of his cabinet ministers in the same matter are jailed. Two, of
there
course,
is no precedent.
Yeah, there is no precedent. So I'm just saying, obviously, there is something, there is a smoking gun. And therefore, one has to sort of not treat this matter in a frivolous manner and suggest. There is even Miss K. Kavita, if you remember, just a few days back picked up and now again denied sort of bail. And who knows, this could go on for months. We already have Mr. Sisodia's case. We already have Satyendra Jain's case. So this case seems to have something in it that is sticking. Now, if that is the case...
Listen.
Do we as citizens of Delhi who voted Mr. Kejriwal think that he can continue to work in our best interests when clearly the allegation is that he has not? So I'm invoking spirit here.
Okay, now the answer is very simple. The citizens of Delhi did not elect the ED to knock off an elected chief minister, nor did the citizens of any other place in India.
Okay.
It would be highly dangerous.
No, so then
if you were to just now, don't interrupt me, please.
Yeah.
It would be highly dangerous if you were to usher in a police raj like that, where every policeman had the right to knock off any politician that they didn't like. So today it's the chief minister.
Okay.
Tomorrow, supposing you had an ED chief who didn't like a particular prime minister, do you think that he could also arrest the prime minister and say, okay, continue from jail, but you can't actually continue from jail? So therefore, the call which has to be taken from Parliament.
Okay, are we being slightly selective? I remember there was a Gujarat riots that took place in 2002, and the sitting chief minister at that time was Mr. Modi, and at that time, the ruling dispensation of the day, many people say, came out and said that Raj Dharma must be upheld. And the opposition, specifically the Congress, etc., came out and said that, look, the man must quit on moral grounds. So,
are you telling
I'm
me
only
that
asking you.
Bihari Vajpayee was wrong?
I don't know.
Are you
I don't know.
No,
I don't know. One second, Mr. Hegde, the person gave a nudge. I'm asking you a question. And therefore, I'm asking. If Mr. Atal Bihari Vajpayee was right and it applies to Mr. Modi, why can't it apply to Mr. Kejriwal is my fundamental submission.
Okay. Now let me answer you. Firstly, it was Mr. Vajpayee who gave the Raj Dharma nudge. He was prime minister. He didn't enforce the nudge, and thereafter lost the election. But be that as it may. The second part is that Mr. Modi was never arrested. That's a huge difference, right? He was under investigation. The investigation finally culminated. Then there were objections which went through the courts.
You're actually underlining my case. A person who's not even been arrested, people wanted him out of office. Here a person has been arrested. His cabinet ministers have been arrested. Yet we say, no, give him the benefit of it. Okay, let me just bring in Ujjwal Nikam on this point.
Let me finish once.
Okay, yeah,
let me finish.
Finish. Okay, yes.
See, in Gujarat, there were 2,000 people who died.
Yeah.
Here is a financial transaction where the BJP has admittedly through electoral bonds got 60 crores from the same people who are approvers. And on the other side, there is an allegation.
We can have these. I'm only speaking in terms of. We can't sit here and assess the case. I don't know. That is the Supreme Court's job, the High Court's job to assess the peculiarities of this case and who's guilty, etc., etc. Ujjwal Nikam, I want to ask you. The BJP today says Kejriwal has lost the moral authority to rule Delhi. He should not be passing these orders. Is there anything legally that one could use to build this argument, or is there no legal argument? It's only a moral argument.
Now, let me tell you very frankly, there are two things. firstly, we have to consider whether it would be legal or illegal. This is the first thing. Secondly, whether it would be a proper or improper to work or to run the government from inside the jail. These are the two questions. Now, the person who is enjoying the highest position under the constitution, that is the chief minister post, whether it would be a proper for him to run the government. I'm keeping aside the legal issue because I'm aware that there is no express provision in the Constitution of India which would resist the chief minister from running the government from the jail. No doubt about it. But at the same time, the material question is whether CM can discharge his function as a chief minister as envisaged under the Constitution of India. And in order to answer this question, we have to consider the scheme of the Constitution of India. Now, under Article 164 of the Constitution of India, the chief minister shall be appointed by the governor. Under the second schedule of Article 167 of the Constitution of India, CM has to discharge his duties. Now, it is very clear, one may ask me, what are the duties of the chief minister? It is not only to hold the cabinet minister, but to run the entire administration of the state. So, it is very clear that under constitution, the chief minister holds the position during the pleasure of the government. So, naturally, the governor can remove the chief minister if, in his opinion, there is a breakdown of the constitutional machinery in the state. Now, it is the discretion of the governor at this juncture. Now, since last 2-3 days, we have to see whether there is a constitutional breakdown machinery. Now, you have rightly said that under the jail manual also, there are certain strictly guidelines. And those guidelines are scrutinized to be followed. How the Mr. Kejriwal is going to hold the cabinet meetings, number one. Whether all the decision will be taken only by single-handedly for running the state administration. So it is for the governor to decide. And therefore, under these circumstances, the opinion of the governor is very important. If the governor sends the report to the President of India under Article 293 AB for the failure of the constitutional mechanism, then President rule can be invoked. Now we have to carefully see. You have rightly said there are certain past instances, so far as the Bihar concerned, so far as Tamil Nadu, but there the chief minister was already convicted. So far as the recent incident is of the Sarkar, the then chief minister, Mr. Soren, tendered resignation. So if any person said that no, I will run the government, there is no express provision which would debar me from running. So I think this would be rather improper. Now, governor, the lieutenant governor has to see whether the failure on account of the attending the office of the chief minister, whether there is a failure of the constitutional mechanism or not. This is a moot question. And if the lieutenant government satisfies, then he has to send the report for the constitutional failure of the mechanism. This is the clear provision. So I think it's a more question of the propriety and impropriety arises in the matter.
Well, two views you heard. Mr. Hegde says provisions can be made by the court. They can find a way out. Ujjwal Nikam says it devolves upon the governor to apply his mind, and he has powers under certain articles of the Constitution.